First and foremost, Shelly, this is for you. In recent times with the COVID situation, with the Russia-Ukraine war, and various other challenges at the macroeconomic level, there has been an environment with the work from home scenario where compliance has become challenging. There are various risks associated where employees have the ability, with lack of oversight, to engage in various kinds of frauds and other issues that we deal with. Now, in light of this development in the recent past that we've been seeing, what have been the challenges for corporates in dealing with the increased risk of fraud and compliance? And what has been the response of the management of corporates to deal with this, whether it's increased cost, enforcing compliance, and making sure that governance is maintained at all levels in companies?
Sure, Alina. So thank you for the question. So I would take a step back, and what I would start by saying is that we have really witnessed a paradigm shift as far as the regulatory environment is concerned over the last decade or a little more than that. So what we have seen is increased number of regulation. We have seen an increased number of enforcement actions. We have seen more of sanctions and penalties, right? Which are often percentage of revenue, right? So now what that has done has translated into corporates really trying to see this function, the legal and compliance function, in a much more serious way, right? Oftentimes, in-house lawyers would have reportings to like the CFO, but that's kind of changed now. Typical general counsels today have a seat on the management table. What that does is it continues to have focus on legal and compliance as a very important business enabler. And also what it does is the general counsel is an effective business partner, right? What has also happened is because of the external environment, more and more companies are getting into a situation where they're really developing very seriously compliance frameworks and compliance programs. And a natural part of that is a whistleblower policy or a speak-up policy, right? And what the natural corollary to the speak-up policy or a whistleblower is more and more people are coming forward with concerns and complaints, right? And then going back to the point that Alina was making, and every single complaint that you really receive has to be thoroughly investigated, right? And that puts a tremendous amount of burden, and it's a daunting task to really address all of those complaints. Now, there are two ways to address those investigations. There is one way that you have in-house capability where you conduct those investigations. The other is that your ability to reach out to external experts, such as some on the panel, right? For their expert advice. Even there are situations where there are investigations where you necessarily need legal privilege, right? In those situations, all the more reason that you reach out to external law firms. Now, in all of this scenario, it creates a lot of a cost burden, right? And it becomes very difficult sometimes to balance when your business is probably, if it's facing headwinds in terms of managing profitability, at the same time being able to have the necessary, budgets to sort of have capable teams in-house and to be able to engage these experts. Now, there's one way to sort of manage this challenge is that you bifurcate the complaints or the concerns and investigate some of them internally. The one more complex ones where you have seniors, senior management implicated, or ones which would possibly land up in a court, whether it's on the criminal or the civil side or a regulatory enforcement action. For those, you necessarily should go to external lawyers. So, I mean, that's how we have sort of been managing. And just the last one point is, for in-house counsels and compliance officers, I would always say that over a period of time, you could start to demonstrate value, that compliance is really a business enabler. And by putting in place a compliance culture, you are necessarily, you're setting up your business for a situation where there are lesser and lesser infractions with the law. And that demonstrates, value over a period of time. Yeah.
Thanks, Shelly. Gaurav, moving on to you. What has your experience been?
Can I just add something?
Yeah.
Here? So, just adding value, there's another anecdote that I remembered, and that came to my mind through Arpinder's introduction about Association of Certified Fraud Examiners. So this body publishes a report known as the Report of the Nations, which basically talks about fraud worldwide and kind of dives deep into it and talks about where the fraud occurs from and which segment, which level of individuals committing fraud. So the study basically says that on an average, an organization loses about 5% of their revenue towards fraud and abuse. And especially in these testing times where we're talking about global recession and the hardships that the economy is facing, building in a more robust compliance structure, compliance framework actually helps the organization. I know a few organizations where the compliance function is actually seen as a profit center because of the amount of fraud loss they're able to save.
Thanks, Gaurav. Arpinder, in your experience in doing various cross-border investigations, both internal and assisting corporates in e-discovery proceedings where there are external agencies involved as well, what are the trends that you're seeing and what are the challenges that you have experienced in the recent past?
No, thanks for that, Alina. So I think one is we're seeing a huge explosion of cases. So as an accountant, I'm happy because, our business is contrarian, unfortunately, to business. But, number of whistleblower complaints coming in companies is increasing. I see a lot of youngsters in this room. So obviously there's a generation, whatever you call it now, there are different buzzwords for it. But there's clear non-acceptance of some of the old business practices. I always tell people our forefathers were happy, to go 9:30, come back at 6. They were okay with whatever was happening. Today's generation may be not so tolerant about some of the practices. So we see a large increase of whistleblowing from this new generation of workers. That's one. Number two is I think there's a lot of pressure on people's reputation. Today, as you can see, even in this forum of ABA, there's so many very famous lawyers, CEOs, CFOs, GCs. I think they're all petrified about their personal reputation. Everybody thinks they have a brand. Okay, and now as a result, no one wants to take the risk, right? Because you're working in a company, you don't want to end your career with that company, right? You want to move on. So that's also, honestly, I think, putting some pulls and pressures. You've got independent directors. We know many cases, I'm sure, Sir will talk about, how independent directors, the enforcement agencies can block their salaries, they can block them from traveling outside India, they can do so many onerous issues on an independent director if he or she has put shuts his or her eyes while signing documents or being in board meetings, etc. So a lot of pressure there, and I see that fight. Then you've got the auditors. Being in EY, I can just say that you have auditors who will question you on everything, but there's so much more pressure on them too. There's reporting responsibilities. All of you would know about the SEBI LODR requirements. You would know about MCA. You would know the onerous responsibility of reporting fraud today. There was a whole concept, I'm sure, as accountants would know, bulldog versus watchdog. I think those concepts also, I think the courts have kind of dished. There was a whole concept of management representation. Even that seems to have gone out a bit. So I think you got, as I said, this whole ecosystem which is enabling my business on a lighter note. But I'm just saying that is leading to a lot of pressure and issues. I would also say there's a lot of change in the environment itself. Talk about startups. Startups are currently having issues because they don't have the right systems, as Gaurav correctly said. I would put them as people where they've not yet fixed their system, then things blow up. And you're seeing a lot of them as we talk. I'm also seeing a lot around sanctions, which Shelly mentioned. There's a lot of anti-money laundering, sanction work. Which countries are you exporting to? Which countries are you exporting to? All of this goes into the ED matter. Everyone's really afraid. So to comply. So the question comes in is there's a lot happening in the ecosystem. There's a lot happening with the laws. And there's a lot happening with people who are responsible where they want to bring issues to the surface. So I think overall, I think it's fantastic for the economy because it can only cleanse it. That would be my answer.
A very
I can
valid
carry
point.
on, but I don't want.
No. I think that's a very important point that governance today has become important and significant. And it's emanating from all of these investigations and enforcement actions that are happening, both internally and externally. and a lot of legislative changes we are seeing as part of the global economy, where even India is seeing multiple legislative developments that are talking about corporate governance and compliance, and that's where internal investigations come about to ensure that there is no fraud or corruption or white-collar crimes, as we call it, in the ecosystems. So moving from there, I'm sure all of you have been reading in the recent past of a lot of issues that are coming up with respect to corporates, a lot of large-scale scandals, a lot of enforcement actions, whether it's the CBI or the Enforcement Directorate, under the Prevention of Money Laundering Act or the Prevention of Corruption Act and various other legislations. And with that, Mr. Luthra, to you, what is your experience in advising various corporates in cross-border investigation matters and regulatory enforcement agencies? In your experience, are you seeing the enforcement agencies across jurisdictions cooperating? Are you seeing an increased use of the MLATs or the conventions to seek evidence or information, to summon employees of corporates in these investigations, and obviously the action and enforcement and charging of senior employees, managements, and corporates with respect to these various frauds and corruption issues?
Right. So to answer that straight away, yes, there is a lot more cooperation. And what is happening is that between the MLAT, between the letters rogatory process, and also other bilateral treaties which allow exchange of financial information, there is a lot more cooperation across the board with agencies worldwide. That's something which we all have to be very concerned about. He and I and you are on the are beneficiaries of all the problems that occur. But the fact is that it's important for us to advise our client in a preventive mode. I think that's one of the very important things, and that's where a robust in-house system comes in, as Shelly's talked about. It's very important to have preventive systems and have compliances. As you said, Mr. Singh, the biggest area of concern is startups who grow. I mean, there's an explosive growth. They don't grow organically, as a result of which systems are something people either don't want to put in place or don't put in place or are just not aware of. I mean, you have these young, brilliant, outstandingly brilliant techies who say, why do we need to bother about the law? And this is a chronic issue because technology fast outpaces our lawmaking processes. That's another debate for another day as to whether we really need to relook at our lawmaking. So that's the first part. The second part is that, you have I was talking about requests. So you're having now that for the last few years, you have a lot of the tech companies providing information. Illustratively, Facebook received about 40,300 requests between July and December 2020. 52% were complied. By the year 2019, if I recall correctly, WhatsApp was receiving requests all the time. People used to think everything is safe, it's encrypted, but the fact is that requests were coming in. So, these are the kind of things you have to understand when you're dealing with the kind of lack of privacy. We live in a world where the device that all of us carry has actually destroyed all privacy completely. And then there's an issue, personal information versus non-personal information. How do you distinguish that? And that's a debate which is currently on in the Supreme Court, how much information can be sought or given. Now, the problem that we have is when we're dealing across borders is India, we believe, unfortunately, that's the law since 1974, the fruit of the poison tree principle does not apply. So any information taken irregularly, illegitimately, or otherwise is permissible to be used provided it's relevant and admissible under the Evidence Act. And that's something we really need to understand. And therefore, at times, even legal privilege gets rather diluted when we have raids on lawyers' offices. And that's a matter of reality which is happening across the board. And ED started this a few years ago in Calcutta, and now they're increasing their imprint. One of the things I also want to speak about is, there's a regulatory framework which one can live with, and there are penalty consequences. The other thing is that if you see our legislative system, we are increasing the reach of the criminal law across the board. So the consequences now for people who are found errant or in breach of the law is not just limited to penalty being imposed, but also criminality and consequences, which can, as you rightly said, impact people's careers completely. There are instances where people cannot move on from an organization because they're really facing an action, and that action may be a criminal prosecution. And if that's the case, how do you move? How do you go to another place? Will you get an opportunity, and can you at all move? So these are some of the issues that I would say are matters of concern. Having said that, I think it's very, very important to have a very strong in-house preventive system, but there's a catch there. We generate a lot of paperwork. So while it's important to investigate whistleblower complaints, what always causes me concern, and Alina and I have had a conversation on this more times than one, we were speaking about it outside, is we, in compliance with the international obligations, international laws, let's say the SEC requirements in cases of corruption, FCPA requirements, you end up generating a lot of documentary material. And an investigator now is wise enough for the last decade or so, even more, to say, we don't want anything from you. Just give us your in-house investigation report, where you have signed statements from various people, you have documented the emails. How are we going to deal with this issue? And this is a chronic problem we come across. Therefore, better to be preventive than to have this reaction after the act or after the event. Because after the event, when you get into your internal investigation mode, you're going to probably cause a lot more damage. And the fact is that everywhere the responsibility cast on the auditors, on independent directors is a lot greater. If you look at the Companies Act, SFIO, it's prosecuting auditors, just like that. There are so many auditors. In fact, a while back, the ICI had come to me and we kind of framed a guideline, hoping against hope that the government accepts it, and there's some kind of pre-sanction kind of provision or a permission kind of provision where the ICI has to be asked before auditors can be hauled up for everything. So these are some of my thoughts.
Thank you. I think a very important point that you raised in the midst of all of this is client-attorney privilege. And given that a lot of internal investigations coincide with some kind of external ongoing investigation, or they could precede an external investigation, the in-house counsel who's responsible, of course, internally to assist with the internal investigation, along maybe sometimes with the external law firms as well as external forensic advisors, what happens to the privilege and how do we deal with that issue in terms of the trend we see today with the enforcement agencies? So any thoughts, both from the in-house counsels here and compliance officers and...
With a show of hands, how many in-house counsels are here in the room? Yeah, just very few. So you guys know the pain when you hear the word attorney-client privilege. You've studied law, you may think you're a lawyer, but when you go in-house, you're not a lawyer anymore, right? So the best way organizations deal with this issue is get an outside counsel, right? So any conversation, any email communication, which is serious in nature, which probably the regulatory authorities may pick up, we always try to get an external counsel inside. And there is a proper recipe as to how you follow attorney-client privilege communications. But anytime there is something serious that needs to be discussed, you need to have an outside counsel as part of those conversations. And I defer to Mr. Luthra to talk more about it.
So when you talk about in-house counsel and attorney-client privilege, I say what? The question is really what? We have a problem. The Advocates Act, the Bar Council rules, the law as it is settled by the Supreme Court really says if you have the ability to plead while you are engaged with an organization, then to that extent you will be able to be treated as an advocate and attorney-client privilege will apply. However, if you're in-house, barring a Bombay decision, which still kind of holds a field, and it's a gray area of the law, the Bombay decision applied to the municipal corporation, which said that in-house lawyers with the municipal corporation with the government who plead will be treated as lawyers for the purpose of attorney-client privilege. So that's a 1982 Bombay decision. They tried to get it upset in 2002. Fortunately, the court sidestepped that issue in the 2002 Bombay decision. So that's the one part. While I believe that the practice of engaging external counsel, all the firms will be rather happy with that, and using the external counsel to then work with firms such as yours to ensure that the work product that you're providing, the forensic work or the analytical work product, is protected because it's come through the external counsel. That's one way of doing it. But then we also have to look back and see there is a lot more work that in-house counsel are doing. It is not an era where all the work that we have to do in the context of investigations is being sent to external counsel. Cost is an issue. Management sensitivity and secrecy is an issue. And therefore, a lot of this is happening, and that is not privileged. And that's a serious concern. I think it's time, really, we have to look at the 1872 Evidence Act and do a little tweaking, because this is going to become a greater concern as we go along. One of the ways to do it really is to have general counsel on a retainer rather than completely employed permanent employees, which means that they continue to hold their bar license, because the moment you step into an organization, you have to surrender your license, get it suspended. So that's a mechanism some organizations use by having people on a retainer, and it's a little gray, but at least that allows them to retain the advocate's license and therefore claim privilege. That's a mechanism, but it's difficult to use that on very large corporates, but that's available.
Alina, may I say something? So you heard the GC and the senior sir's view. Siddharth, as Siddharth tells me. So I'm not an advocate, so I can hopefully beat the hierarchy. But coming to the privilege concept, as a forensic accountant, I can tell you it's very gray. Because when the regulator comes to your office, how do you say no to them, you know? They're sitting in your office, they're going to sit pretty much the whole night till you give the data, and they'll arrest you potentially for non-cooperation. So the question is, it's very good theoretically to talk about it, but I think there's a lot of homework which is required to be done to give clear guidance to everyone, I think, in this whole area of privilege. Second, I would say we are very weak in the way we go about planning for privilege. Especially in cross-border investigations. You have data coming from other countries, other states, you move it around. So I think we've also become a bit weak in understanding what is privileged. As Sir correctly said, that only the document or a report is privileged, not the base information. So that is again a thing you all should be clear about, because that is something they can get control of. So lastly, I would just say it should be very clear. When you write privilege and confidential on an email, is that adequate? Is it adequate that some lawyer is copied on it? Sometimes you forget to copy the lawyer and then subsequently you forward it to them saying, hope this continues to be privileged. Then you have an auditor who may ask you for the report. You share the report and say, I'm only sharing with you, but otherwise it's privileged. So there are hundreds of questions which I think remain unanswered. And I would say, sir, the Bar Council should really take this seriously.
Yeah, there's one more thing I want to add, if I may. May I? Look, today in other issues happening, let's say you claim privilege on a document. The moment you claim privilege, it's the lawyer's right to claim privilege, really, that this is a work product that the lawyer has got. Is it privilege in the hands of the client is the question. That's number one. Number two, let's say you claim privilege and let's say this, I'll give you an example. Your device is sought to be seized, or the data is sought to be taken from your device, the dump is taken, sought. You claim privilege on some of them, you're not willing to give it. Agencies are now coming back and saying, all right, you're claiming privilege, you're saying this is private confidential information or otherwise privileged under law. Please describe what it is. We won't ask you for it. Where is there going to be any privilege? And I'm dealing with a matter right now. In fact, as we speak, I finalized an application, settled it just yesterday, because we have to go back to court to say, look, this has to be clarified. The order of the court is sought to be subverted in this mechanism. So these are the challenges that are coming, and we really need to look at revamping the law on this, and it needs to be really pushed with the government, with the law ministry, because otherwise this is going to get chaotic as it comes.
Yeah. I just wanted to add a quick point. I think it's been alluded to, but just From a very practical lens, the challenge with in-house counsels not getting privilege, having the advantage of maintaining privilege, or the fact that it's kind of gray, it becomes very complicated, especially because when we as lawyers are not clear on where privilege applies, just imagine you are dealing constantly with business people. They have no understanding. A lot of them do not even understand the term privilege at all. That's one. Second, when you are a part of a large multinational or a global conglomerate, the in-house lawyers in other jurisdictions in the same company do not even understand this piece. They assume that you are an in-house lawyer and your privilege will apply. So these are all the very pragmatic, difficulties from a pragmatic lens that, we have to deal with. And I really like the point you make that the law really needs to change on this.
I would just like to add one point here, and I think, Ms. Luthra, this is something that you should add in. At the investigation stage by external agencies, there's no exception for privilege, which means that the investigating agency can, during the investigation phase, obviously pick up privileged documents, and you can only claim the defense of privilege when you go into the actual stage of prosecution. So the key point is the investigation itself, whether it's by the CBI, ED, any enforcement agency, and if it is cross-border, then by multiple agencies across the globe, goes on for years. They are able to pick up privileged documents and you cannot refuse. I think Arpinder said if the enforcement agency is in my office, I'll get arrested if I say no, even if it is privileged. Because by law, they are entitled to procure that data, irrespective of whether it's underlying documents or it's a work product. And if that is the case, and they can therefore, like I would like to say, Mr. Luthra, decipher it, reconstruct and go to the original source, the question that arises, at least in Indian law, is on the one hand, our corporate laws, our Companies Act is imposing obligations on the directors to internally investigate and remediate frauds, etc. On the other hand, when you investigate and remediate, the same very data can be picked up by the enforcement agencies to prosecute the same very companies who are adhering to the law. It's an interesting problem, and it all ties up to privilege. And I think the key question here is at what stage can we get privilege? What is the impact on the corporate here? I think both in-house counsels have raised some very valid points and difficulties. So your thoughts on this?
So that's a very interesting point you make about how seizures actually take place. And that's what I mentioned earlier about the fruit of the poison tree principle. Once they're in your establishment, they can pick up anything and everything. In the earlier days, what people used to do was to avoid getting material picked up, feeling that lawyers' offices would be safe, they would actually transfer all the data, physical data or electronic, to the lawyer's office and say, listen, it's lying with the lawyer, and the lawyer could claim privilege. But that's really not happening. Privilege is claimed during trial, during the proceedings, civil or criminal. And I think it's important now, especially after the privacy judgment, to define not just what is privilege, but what is private. And that'll have to be done legislatively, because there are two parts to it. One is what is contained in the Evidence Act. The other part is that in terms of privacy, now that it's recognized as a constitutional right, would there not be material which may be private? And the third aspect, of course, is going to be commercially sensitive information which has no relevance to an investigation, which is taken away and then either selectively leaked or just leaks through the gaps. That can be disastrous for an organization. And that's something which we are trying to fight back. Unfortunately, this has not received any legislative attention at all. In fact, it's to the contrary where, as you rightly said, across the board, whether in the Companies Act or in the Information Technology Act, every legislation you have it is casting more onerous responsibilities on the PMLA, of course, income tax, are casting Companies Act, are casting responsibility on individuals in positions of responsibility, whether they be independent directors, auditors, or other professionals who work with an organization. And add to that the whistleblower policy, which is, I must say, admirable and important to ensure good governance. But the actual impact of that is very disastrous. when it comes to dealing with the prosecution, because the whole basis of your right to innocence, the presumption of innocence, is out of the window.
I think to that, I'll just add one more point, which I think is relevant from a business corporate perspective. The reason why governance is introduced or vigil mechanism is introduced or fraud control is introduced is to protect the corporate and the shareholders who are investing in it, to ensure that the economy operates in a compliant manner. Now, you have listed companies, right? And you have private companies in the Indian context. Now, there is a lot of sensitive data that exists in the listed companies. The impact is larger where there is a fraud, because then you're talking about public shareholder funds, and the larger frauds that have in the recent time come up, and some of you may have read about it, would be with respect to listed companies. But what is that fine balance between internal investigations versus external investigations and the requirement of disclosures to the stock exchange? There's been a change recently which requires listed companies to disclose to the stock exchange at the commencement of any internal investigations with respect to their financial records. And after the completion of the investigation, they are again required to inform the stock exchange and make public the internal investigation. Of course, they have the right to redact it, but the question here is, what is that balance between transparency, governance, and maintaining shareholder value with respect to what we are trying to achieve here? And with this, I think we move to the next topic, which is important and probably the last one I'm going to pick, which is, I think everyone touched upon it, the issue of privacy. Now, most of the investigations that happen, whether they are internal investigations or being done by external agencies, rely upon a lot of forensic data being collected from mobile phones, from your iPads, your tabs, your laptops, etc. And when you're accessing that information, various legislations come into play. And what we all know in the corporate world is the information sitting there is not restricted to business information that is being investigated. There is a lot of personal information. So the question that arises here, and I will leave it to all of you, I think all of you have had experience, what are the key challenges with respect to the data privacy issue in doing these internal investigations, cross-border investigations?
So thanks for that, Alina. That's really right up to what we deal with on a daily basis, actually. Because for all you know, as we start investigations, the first step is to collect data. There's nothing else, right? You can't do anything without data, right? Unless you're a good lawyer and like Mr. Luthra, who cracks a case just based on the interview, But otherwise, most of us need a lot of data to prove our point. So how do you get the data? Especially as you know, most Indian companies are no longer just Indian, right? A lot of private equity investments, a lot of global joint ventures. They have operations in Africa, Middle East, UK, US. So Indian companies are no longer Indian companies. They're global companies. So data privacy doesn't just relate to a multinational operating out of India. It also relates to Indian companies operating globally. So I think data privacy is now becoming more and more complicated, not just for India, but for their operations outside India. I think the first thing is planning. I tell every company that you must plan it out properly, that where is your data lying? What data do you want to see? Is it cell phones, computers? Is it specific? I think we spend very little time in planning, honestly, in investigation. I think it's 50-50, where some clients spend a lot of time, and I find those are more European clients because they have GDPR, as all of you would know about. So they are very conscious. German companies, Swiss companies specifically, I'll point out as two countries, very, very particular about data privacy. In fact, we'll debate the engagement letter. Forget about the data. My contract with the company will be debated for 6 months. That what GDPR, I think by then the suspect would have left, run away, been in the Middle East. But it takes about 6 months to close an engagement letter with a German or a Swiss client, sometimes. Second is, but it's important, I think. It's important to debate it. Second is, where is the data lying? Sometimes you could have an international citizen working out of India and you want to image their devices, very complicated. When you have an Indian citizen who worked in India through the moment of the crime is now sitting in Singapore or Germany, what do you do with his or her data? So very complicated questions which have to be dealt with right up front. So I think, as I said, planning. Second issue we face is personal phones. No, today you realize those days where people will send silly emails on the computer saying, oh, pay this money in my bank account, or let's pay this bribe. Those days are over, I think. Unless you got a really silly guy, he's fresh out of college, first year, and drops a bomb, which is sitting on an inbox. I'm waiting to see that. In the last 1 or 2 years, it's been a little difficult. But it's all on the cell phone. Honestly, everything, as Mr. Luthra said, is on the cell phone. WhatsApp, Signal, Telegram, you can call it whatever, but similar platforms. So all business I find is done on WhatsApp. Okay, people have business accounts, etc. In fact, I was saying we must have DLP. All of you would know what DLP is, right? The process of examining emails to see what can be sent out of the company or not sent out of the company. A lot of software companies have made a lot of money selling DLP software. But I think there's no DLP on WhatsApp, right? I mean, who's checking which WhatsApp is going out of your company's network, which is staying inside your network, how long you should keep WhatsApp. You talk about email should be kept for 2 years, 3 years, 5 years. There's some confusion around that too, which should be clarified at some point in time. But WhatsApp, there's no clarity. In fact, a lot of times we were investigating a case 2 days back where the person came to the interview. We asked, can we image your phone? He said, definitely. He took his phone and deleted all his WhatsApp and says, please, go ahead. And there's nothing you can do about it, right? First, you need consent forms, and then you need all of that documentation in place. So very, very complicated position. I would just, in summary, say that please make sure that if you do cell phones, most of them are private. Please ensure consent forms, lawyers are consulted. Don't just do a immediate investigation where you grab the phone, there's no documentation signed. He will file a legal case against you in the evening if you got a smart lawyer of one of you out here. And you will end up going to the police station for the next 6-7 months explaining why did you take this phone when it was a private property and you did not have permission for it. So I think that's the most basic thing. Second is, in the private phone, can you just have a party looking at his exchanges? Let's say the person is doing something irregular in his personal life. Okay, Alina told me to be very compliant, so I'm not saying anything more. But let's say he's got his personal life and then he's got his professional life. Can you look at his personal life and take advantage of that when you're looking at his professional life? You can't. So you have to really segregate what you look at and how you look at it. If the person has a personal bank statement which has a password, there are some people who have given legal opinions that you can't crack the password. That means you're going into his private information. If it's got a bank statement without a password, there's still a gray area. That is it something you can just look at. So it's all extremely complicated. As I said, it requires lawyers to look at. Now, I know Alina is looking at me angrily saying I must shut up. But the reality, I must talk about cross-border. It gets even more complicated. Now, let's say you're doing an investigation, India matter, which has a German connection. How do you do that investigation? The data can't move. Trust me on that. So moving German data from Germany, Stuttgart to India, you can just about forget it. All of you have heard of Schrems and other things. I'm assuming you've all well read up lawyers. So the fact is, India is obviously without a proper data privacy law. I don't think it meets the high end of compliance with a EU country wanting to feel comfortable sending their data to India. So as a result, you'll have to have a cross-border investigation where someone's sitting in Germany, he or she is investigating there, and you're sitting in India. A lot of people sometimes act smart and say we can have it on a German server, and we will log in through Citrix and look at it. They're thin clients, all this technology jazz, which lawyers don't understand sometimes. So they sometimes say, okay, go ahead, because they don't really understand it. So it sounds kind of cool. But I think there also there's a problem because of the fact that the law is a bit gray, that you have to have somebody sitting in Germany reviewing the data. You can't have somebody sitting in India reviewing the data in Germany. So it becomes really complicated to manage the case. Now we go to the last aspect where I'll then hand it over to my colleagues. The data investigation's over, you've proved the crime, somebody did it correctly sitting out of Germany, somebody did it sitting out of India, some really good law firm, and I've got many here from Baker McKenzie, so hope it's Baker McKenzie, or you could have Alan Overy, they're lawyers. We work with all, so I have to be honest about it. But the fact is that you'll have this very good law firm which will now say we have to do regulatory proceedings in India with Mr. Luthra. Now the question is, how do we get this data from Germany to India? Because you have to fight this case. Now that's a whole different segue which I'll hand over to Mr. Luthra and ask him.
So the problem is, till we have a cogent data privacy law, we're not going to get very far in India. And then the issue, as you rightly said, was there are variant standards in different jurisdictions. So how do you access, how do you protect, how you maintain data? Traditionally, this issue used to arise only in the field of extradition. today the world has changed, and one of the fundamental issue is how do you get information? If that information is protected by various laws, and that's what happens sometimes when we make requests to other countries. India may be very, very liberal about giving information. Other nations are not. They have very strict compliance regimes, and that's where the variance happens. Having said that, the problem that we face is an Indian investigator does not understand international norms or chooses not to understand. And for them, it's very easy. They want information, let's say, from entity X, based in India. They have a unit in India. They have people overseas. Earlier, it used to be a very simple mechanism, and that's the practical reality of it. They would just call the MD or the chairman of the Indian entity and make him sit and say, listen, sort out this information. Please make sure you get it. And that individual has absolutely no basis to get it. He may not have access to the information. He's just a subsidiary or one of the downstep subsidiaries or organizations. And thirdly, he also cannot act in breach of that law. So how do you deal with this? I think we have to wait for a time when we have a more globalized regime which will allow us to be more efficient in investigation and the use of data. In India, of course, it's a free-for-all. I'll leave it at that.
I think I'm going to just wrap this up and open it up for some questions. But I think one related point that we have been seeing over the years in investigations, a lot of times now it's not an internal investigation emanating from a whistleblower complaint. It could be an e-discovery process pursuant to summons being received by the corporates or employees of the corporates with respect to it could be a cross-border issue, it could be an internal India-related matter or scam, and you are conducting an e-discovery to be able to respond to that summon and answer or provide the information that has been requested for. And to Mr. Luthra's point and Arpinder's point, when you're actually collating the information, you may or may not, as a corporate, be in a position to access that information. The biggest challenge that I've seen is that the enforcement agencies are waking up after 10 years or 11 years in a case and asking you for data that goes back maybe a decade or longer. Now, those files may not exist. The companies may have merged. They may have either demerged, and the data is just not there, right? How do you collate that data and provide that data? Let's assume you even manage to give them the data. The investigation phase from there onwards goes on for years. A lot of employees have left. The data is somewhere else. No one has continuity. So how do you manage the entire process of investigation and then, of course, moving to the trial level? And finally, the conclusion, I don't know, Mr. Luthra, what your experience is. Let's say a PMLA case, how long would it typically take to conclude?
They need to begin first.
That is what.
In the Augusta Westland case, they filed the 10th supplementary complaint, and I don't see the matter proceeding at all. The problem that we face is also, and an added issue which I should have mentioned is, there are requirements under income tax laws as to how long you have to retain specified data. That's one part, or under the Companies Act. But in terms of the data that we have on emails, correspondence, etc., it's normally based on internal policies. Now, there are two challenges, and one of the challenges I'm facing right now is how do we explain to the investigator that over a period of time, because we are an international organization with a presence in India, the policies, data retention policy has, let's say, gone from 7 months to 13 months to 11 months and 15 months. And therefore, for different periods, you'll have different levels of data which is retained. Once you put a data freeze, it's a different matter. But till then, there's a problem. So there has to be coherence in that. Now, there are two problems that arise with that. One, the moment you say it's not available because of data retention limitations, there is suspicion cast on you that you've probably done away with it for extraneous reasons. That's one. The second issue is, how do you prove a valid transaction or a valid defense? Let's say the investigator, and unfortunately, a lot of our laws, including the PMLA, cast a reverse burden, which is abhorrent to the presumption of innocence, but that's the way it is. And it's casting a reverse burden, not just where prosecutions are there, but also where penalties are imposed. So once you have that reverse burden, how to discharge that onus? Because you don't have the material to discharge the onus. And that becomes an added issue. So I think internally this is something which organizations need to work about, that in a country like India where matters will take decades, should we not increase the data retention policy? Now, I know there are costs involved and there are technical complications also as to how much data you're going to retain and how you're going to manage that data, and whether you are compliant with international obligations where the company is really a unit of a foreign entity. So all these issues have to be looked at. Otherwise, we're going to have a serious problem in nations, not just India, but in all nations where the criminal justice administration, we should not call it a system, works rather slowly. You will have to have that data to discharge the reverse burden which is imposed on you.
Thank you, Mr. Luthra. With that, I think I will open the house for any questions that anybody may have.
Good afternoon, panelists. Thank you for your inputs. Actually, I have a question regarding Infosys recently introduced a non-compete clause where they have specifically mentioned the company's names like Wipro, Accenture, that the employee can't work there after their work period. So in US, in the West, this is a common practice. So should we move towards, like in the age of globalization, adopt the common practice, or still it's in violation of the fundamental right to work?
No, I think you can have these non-compete clauses for a period of time. They've been accepted in Indian law, and they're legitimate for two reasons. One, you are a carrier of trade secrets which you worked on, and B, all those trade secrets normally have a shelf life. So therefore, it is not can't be a permanent ban, but it can be a limited 2-year, 3-year, 5-year ban, as the case may be.
But should they mention the names of the company in their clause?
Look, normally you don't mention names. Most of these clauses normally don't mention names. They actually refer to the kind of work you will not do, which is still larger. It is much more broad-based. So that's what is the normal trend. In fact, I don't know, I remember at the early years of my career, the East India Hotels Group used to have clauses where they used to restrict people from working. They had bonds and conditions such as that, because they didn't want people to go to rival organizations once they had undertaken training. And that was one of the early issues which used to be challenged all the time in courts. So these clauses, these non-compete clauses, non-disclosure agreements are very crucial for any organization. Otherwise, in a way, in the age of ideas, you can't have people floating around by what they have within their minds.
I have one more question with Arpinder sir. So in the recent data governance policies, now the big tech companies like Facebook, Twitter have the monopoly in the market. But should we move towards establishing an independent regulatory authority in India? Like the Supreme Court recently suggested this, that retired Supreme Court judges can establish an independent regulatory authority in India and regulate the policies which are governing the big tech companies like Twitter, Facebook.
So I think this is more a technical legal question.
Listen, they're my clients, so let me be a little discreet here. All the companies you mentioned are my clients. I have two concerns. Why do our courts need to step in and regulate everything? This era of judicial legislation is, according to me, a breach of the separation of powers principle. That's one. There are cases where it's necessary, but I think sometimes, and speaking for myself, while if you look at the new election, the judgment, the Constitution Bench on election commissioners, one of the questions we have to ask as students of law is that not a case of overreach? That's one. The second thing is there a need for regulators? Yes, there is, but the point is, if you look at the 2021 guidelines that have come in under the IT Act, you'll find there's a rather comprehensive, robust environment that has been created, perhaps too robust for the liking of a lot of the tech companies, and that's why it's under challenge. So there are mechanisms within the law. It's not necessary that we have to transplant. I know we have a lot of judges from the Supreme Court who retired because terms are shorter, but we don't need to necessarily re-employ them all the time in doing things like this.
Do we have any other questions? Oh, sorry.
On the related point, you yourself mentioned the 52% enforcement rate in dealing with requests. How can we make that better? And do you think companies should be in a position to not to reply to a request?
My question is, should it be better or is it not good enough? So therefore, the point is this: any request that is to be made for information has to be within the ambit of law. Very often agencies will ask you for information which is a fishing and roving inquiry, which is not even related to the nature of investigation they're doing. And you see that increasingly. In fact, we are up in challenge against these fishing and roving inquiries for certain organizations in court because that is becoming the order of the day. Therefore, my view is that while an investigator acting within the ambit of their powers under their special laws or the general laws are entitled to seek information, but you can't just seek everything under the sun. There are issues of privacy, there are issues of privilege, and there are issues of relevance to the investigation you're doing and relevance to the law that's being applied. So all those parameters have to be concerned. On the other hand, on the flip side, since I do occasionally appear for the prosecution as well, the problem that an investigator has, and this is, in hard crimes, it's a serious problem which we all need to understand. There is somebody who puts up a post on social media about a child who's kidnapped. The investigator has 48 hours to try and recover the child because by that time, the demands are not met, that child is going to be dead. What do you do? So these are challenges that investigators also have. Because, by way of example, how long do you think a request takes in terms of an MLAT? 4 months? And we have hundreds of requests all over the world. And then, of course, we have, there's a very interesting thing. While India is normally a little liberal about giving information to others, you will find that a lot of information that we seek sometimes is subject to multiple challenges in those jurisdictions. Incidentally, there's a matter which is pending here in the Supreme Court right now. We lost it in the High Court, which is pending on the extent of information that can be sought and to what extent can the sovereign, the government refuse to give that information under a letters rogatory process. So that's a matter which is an ongoing thing. Hopefully it'll be decided in the next few months and pending for a while.
Thank you.
Any other questions?
Thank you, sir. My question is you mentioned about GDPR and sharing of data. In other jurisdictions, European jurisdiction, there is a sectoral-wise classification of consent. So they have taken a very nuanced approach, consent within consent. So do you think India should also follow a similar approach, like in terms of sharing data and following up with the compliances?
I think I'll give my accounting view to it and then I'll give it to Mr. Luthra and the lawyers on the panel for the legal point. I think it should definitely be sector-based, in my view, because financial services has so much more confidential information around customers, the whole Aadhaar card discussion which happens around masking, etc. So I think it happens to some extent in India today, even if we don't have a data privacy bill, by the way, because we have the Information Technology Act. We have, under financial services, RBI has given out a lot of norms around confidentiality, protecting the data. So I think India is informally, like Mr. Luthra was alluding to, we are informally complying with data privacy requirements, but it's very sector-based. Some sectors are extremely strong, especially, I would say, in the financial services, NBFC, even these new fintech companies, a lot of them have been blacklisted for KYC because they have not been masking their Aadhaar information. So I think the government has done the sector-wise, and I would obviously recommend we do it similarly, but Mr. Luthra, more from a legal perspective.
So I think there are specific laws and regulations which provide for protection of data, but right now we don't have a comprehensive regime which we really require. So there will really need to be an overarching regime in the context of the legislation that the government is trying to place, I believe, before Parliament in March. 10th March, I think, is when it is to be placed. Having said that, there will have to be sector-wise specific regulations, and that will be provided not necessarily in the generalized law or the overall Data Protection Act, but Data Privacy Act, but it will have to be applied in the sector-wise regulatory mechanisms, the legislative mechanisms we have. In fact, one of the things that we've started doing for a very long time is redacting information. That's something which is not really acceptable under Indian law. There's no legal mechanism that provides for it, but we are doing it all the time. And investigators also do it, we also do it. Investigators can do it, for example, under the Unlawful Activities Act. They have a mechanism where they can mask identities on the National Investigation Agency Act. But otherwise, we're doing this in commercial matters, we're doing this where we in contractual issues. So that's happening all the while. So there's a very interesting thing. We are applying a lot of Western principles or international principles in the application of normal litigative processes. They're not necessarily entirely backed by legislative provisions, but it's being accepted and it's becoming a norm, really.